What's up, Colorado Realtors? I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. On today's episode, we are going to be talking about contract offer and acceptance. It's one of the most common questions that I get as I'm out talking to realtors around the state, as I'm answering the legal hotline. Confusion relating to specifically offer and acceptance and expired offers and so on and so forth. So I want to just clarify and give you some thoughts as it comes related to this stuff. First of all, under contract law, and this is like, takes me back to my days of law school, but under common law principles of contract in the United States, a contract requires, in order to be valid and formed, it requires certain elements to it. And I'm not going to get into all those elements, but the two first and foremost elements are offer and acceptance. It requires consideration and mutuality of agreement, and a handful of other things, a writing in the case of stuff that most of you are doing when it has to do with moving or conveying interest in real property like you all are doing. But anyhow, it's got a whole bunch of things that it has to comply, but offer and acceptance are the first two elements of the contract. And of course, in the Colorado Commission approved form, it's all set up to address all of the elements and make sure that we can create valid contracts when you guys are using the forms out there. One of the, this is a free piece of information, a derivative piece of information, consideration. A lot of confusion around the state about consideration, people believing that earnest money is the consideration that forms the contract. It is not. Our state form contract, what is the consideration in that contract that satisfies the element of consideration are the parties' mutual promises to each other. That's the consideration. It's not earnest money, so technically you don't need earnest money in order to form a contract under our Colorado Commission approved forms, but that is a very common misperception that I know a lot of brokers or realtors around the state believe. Don't fall into that trap. But as it relates to offer and acceptance, our contract has an acceptance deadline. And so typically what happens is a buyer makes an offer to a seller, and that offer is good for up and into can be accepted up and into the acceptance deadline. And let's say that's 3 p.m. on a Tuesday. Well, from a pure contract law standpoint, at 3:05 or even at 3:01, that seller cannot accept that contract because the offer is gone. In other words, you don't have the basic element of contract of offer. You might have acceptance and consideration and all of the other elements, but you've lost offer because the offer expired at 3 p.m. So 3:01, it's no longer available. So I like to tell brokers that you can, and this is a quote that I use all the time, you can never accept an expired offer. So the seller can't just sign that contract at 3:05 or whatever time it is, but you can always counter an expired offer. In other words, all of the terms in that original contract may be acceptable to the seller. If that's the case, then what the seller can do is just counter that offer and keep all the terms in place. In the counter proposal, they would put in a new acceptance deadline, and then once the buyer receives that counter proposal, signs that counter proposal, incorporating the new acceptance deadline that the seller has now proposed, as well as all of the original terms that the buyer proposed in their original contracts, you formed a contract, right? Because now we've got an offer coming from the seller going back to the buyer, and the buyer accepting. So now we have all of those contractual elements. So remember that you can always counter an expired offer, but you can never accept an expired offer. Now, there's theories of law, that I won't get into here and that you guys don't even want to be messing around with that might ultimately form a contract, even if it was accepted late, right? There's reliance or performance kind of theories, estoppel theories that might ultimately create a binding contract. But as a broker, you don't want any disclarity. You want contractual clarity when it comes to everything that your clients are doing. And you don't want them to be out litigating or having to engage those nasty attorneys as they're trying to figure out if they have a contract or they don't have a contract. And you can do that by having contractual clarity. So you can always you can always counter an expired offer, but you can never accept an expired offer. So of course you can do that, but you can also communicate. That is what your title is broker. In addition to realtor, you're a broker. And so that oftentimes involves communication. You can also pick up the phone and call the buyer's broker back and say, hey, we're willing to accept your offer as it was written. We've missed your acceptance deadline. Please update your acceptance deadline. Give us another half a day or hour or whatever it's going to take. Send it back over, and my seller is willing to sign that. That's another way, of course, you can do it. But it requires some communication, some brokering. So those are two solutions for dealing with expired offers. Hopefully that helps address what I know is a very common bit of confusion and misunderstanding among a large section of the brokerage community. And that's what we're here for on Legal Bites, is to try and address some of those confusing points for you. As always, if you have other confusing points, the legal hotline is available from 9 to 12 and 1 to 4, Monday through Friday. And I would encourage you guys to utilize that. If you have questions about offer acceptance or anything else you might have questions about, we'll try and get you pointed in the right direction. Thanks again for joining me on another edition of Legal Bites, and we'll see you soon.